Good morning. Thank you for joining us today. My name is Sandeep Gokhale, and I'm here with my colleague, Leah Simon. Now, usually when we host these HR review seminars, we do so in person, in a large room, often at a convention center where we enjoy breakfast together and time to connect up close and personal. These days, of course, sharing a room with hundreds of people is simply not in the cards. So we're here today via Zoom. Now, we have over 1,500 people registered with us today. And while this is super exciting, we also look forward to the day that we get to spend time together in person. Until then, please keep well. Now let's turn our minds to today's topic: lessons learned from 2020 and what to expect in 2021. Let's just say, as HR professionals, operators, and business owners, we've done a lot of learning in 2020. That said, we're going to use the next hour or so to tackle what we thought were some of the biggest challenges employers faced in 2020, and then look forward to 2021 and forecast some of the issues we foresee arising. I will start off by tackling topics today that stem from terminations and closures, specifically in the context of work from home arrangements. What can constitute a constructive dismissal? Next, I will turn to the infectious disease emergency leave and discuss considerations that should be on our radar if we are terminating an employee's employment who happens to be on this leave. Next, I will address mass terminations, before I conclude by discussing a recent development regarding the enforceability of a termination clause in an employment agreement. My colleague Leah will then look into her crystal ball and take us through some of the challenges we foresee associated with a return to normal. Specifically, she's going to speak to managing requests for accommodation due to mental health issues and COVID-19 related fears. She will then navigate us through the infectious disease emergency leave before ending with an incredibly hot topic on whether businesses can require employees to be vaccinated, which I think is an issue that's going to be on all of our radars as we start looking forward into a potential vaccination. Now, the format for this morning is as follows. Lee and I will speak to you for about an hour and we'll end sharp at 10 o'clock. From 10 to 10:30, we will answer your questions. Now, if you have a question for us, please type it into the Q&A box on your screen, which I'm told is not to be confused with the chat box. We'll do our absolute best to make sure we get all of your questions answered. However, if we don't get to your question, please reach out to us after the presentation and we'll make sure all of your questions get answered on our time. Finally, a recording of this presentation and a copy of the deck will be available on our website within the next day or so. Once again, thanks for joining us, and let's get started. Now, a frequent issue that has arisen over the past 9 months relates to the physical location of the workplace and constructive dismissals. At its most basic level, a constructive dismissal arises when an employer makes a unilateral change to a term or condition of an employee's employment. Now, it's not just any change. Courts and tribunals have traditionally determined that a unilateral change has to be to the detriment of the employee. In addition, this detriment needs to be quantifiable. And remember, we're talking about unilateral changes here. A constructive dismissal claim does not arise when an employer and an employee agree to a specific change. So using that as a baseline, there are a couple scenarios I want to walk you through. The first scenario centers around what we have all lived through over the past 9 months. To simply asking an employee during a pandemic like this to temporarily work from home or on the basis of a constructive dismissal claim. Now, despite what plaintiff's counsel will suggest, the short answer is no. A temporary requirement that an employee work from home right now, based on the recommendation of public health experts, is not going to amount to a constructive dismissal claim. However, the second scenario I'm going to discuss is where it gets interesting, and that's when the work from home request becomes permanent. Now, it's no secret employers right across the country in almost every sector have teams modeling what a permanent work from home plan would look like for some and or all employees within an organization. So the legal questions that arise are A, where's the detriment to the employee? And B, can the detriment be quantified? Now, while a large segment of the population considers working from home a benefit, and I want to be clear, my personal view is not aligned with this, as I have 2 kids who love to interrupt Zoom video calls. There are going to be situations where an employee says, my living situation is simply not conducive to me permanently working from home. Perhaps they have multiple roommates or have young kids at home and live in tight quarters, or live in rural areas where reception and internet connections are simply not stable, kind of similar to my basement in Toronto. I think in these specific cases, an employee could have a sympathetic claim towards demonstrating a constructive dismissal claim because they never purchased the house or entered into the condo lease knowing that they would be required to work from home. Additionally, when they accepted the job, it was to work in an office. Again, the employee still has to prove detriment in a case like this and be able to demonstrate an inability to actually perform the job, which will equate to that the impact of the change. In these cases, employers are going to have to utilize notice in terms of getting around what could be deemed to be a constructive dismissal claim. Now, the amount of notice required would be specific to the employee in question, but like always, the more notice we give, the better we are. The other consideration pertains to the costs incurred by an employee from working from home. Now, creative plaintiffs' counsel are going to try and argue that if an employer doesn't provide some sort of stipend for the cost of water, energy, internet, office furniture, supplies, and etc., you potentially have a scenario where the personal costs incurred by an employee for simply working from home start to add up and hit the threshold for a constructive dismissal claim. Now, courts have generally stated that unilateral changes that create a 10 to 15% reduction in earnings will lead to a constructive dismissal claim. So I think plaintiffs' counsel will try and argue the reverse, that the costs incurred amount to that same 10 to 15%, and therefore an individual's employment has been constructively dismissed. So if you're an organization that is contemplating making a move to a permanent work from home environment, you may want to proactively address these issues in your rollout and in your policies. Now, the third scenario I want to walk you through, and it's the more likely scenario to arise, is when we start to require employees to return back to the physical workplace. I anticipate many of our employees are going to say, no, it worked well for a year. I would like to simply continue to work from home. Now, leaving aside the accommodation requests due to fears and personal circumstances, which my colleague Leah is going to address in detail, the mere requirement that an employee return back to the physical workplace would not, on its face, in my opinion, constitute a claim for constructive dismissal, because there hasn't really been an effective change. Now, change is the key component here. And there's a case I want to bring to your attention from 2017. In this case, which is cited in the deck, you had an employee who lived in Waterloo, and the head office of the organization was located in Vaughan. And the employee had negotiated an arrangement where she would be able to work from home for 3 days of the week and go into Vaughan 2 days of the week. And she did this for 22 years, where there was no issues with respect to performance. In 2015, the company was acquired, and Newco came in and advised the employee that she could no longer work from home without providing any notice, rationale, or explanation. They simply wanted everyone in the office. About a month later, the plaintiff resigned, claiming she was constructively dismissed because her long-standing work from home arrangement for 3 days of the week was unilaterally changed. Now, the court went through a detailed analysis focusing in on travel time and the cost associated with travel. Specifically, the court did an analysis based on traffic patterns and studied the 401 and the 407 and determined that the drive would cost the employee 3 hours per day. So that's an additional 9 hours per week. Additionally, the court looked at the cost of gas and included several comments on the safety hazards of being on the road for an additional 9 hours per week. Ultimately, the court did determine the employee had been constructively dismissed and awarded a common law notice period based on her 22 years of service. Simplistically, the court found that there was a unilateral change to a term and condition of her employment, and the change was detrimental to the employee. And they were able to quantify the detriment based on the analysis of time and money associated with the travel. So all of this is to say, as we implement our return to the workplace strategy, we need to separate scenarios where we are changing terms, like in the Waterloo Vaughan case, as opposed to simply returning to the pre-pandemic terms and conditions of employment. I now want to turn to the infectious disease emergency leave, otherwise known as IDEL. And we've all become quite familiar with this piece of legislation over the past 9 months. Very briefly, in response to the pandemic, the Ontario government enacted a regulation that amended the Employment Standards Act rules during the COVID-19 period. Now, the changes were principally twofold. On the one hand, the regulation provided job protection leave for employees. And it was job protection leave based on an employee's own health issues in terms of being symptomatic or having to self-isolate and quarantine, as well as providing protections for an employee who had to provide care and support to a family member for a COVID-19 related reason, including issues related to kids not being able to attend school. On the other hand, the regulation also provided many benefits for employers. For example, prior to the introduction of IDEL, if an employee put an employee on a temporary layoff, the temporary layoff would be deemed to be a termination if the employee was not recalled within a 13-week period in a 20-week rolling period, assuming no benefits were provided. Now, many employers were concerned with these timelines because they didn't want to incur the costs associated with the termination. So IDEL addressed this concern and automatically deems these employees who were put on temporary layoff to simply be on this IDEL leave. Now, the government wanted to be crystal clear when it enacted this legislation. They wanted to ensure employees couldn't be retaliated against or reprised against simply for needing to take an unpaid leave if they were exercising a right under this regulation. However, this does not mean that employees on IDEL are completely immune to having their employment terminated. I want to provide you with 2 examples. For example, if an employer has decided to eliminate an entire department, and this particular department has employees who are currently on IDEL, the employer can still continue with their restructuring plans because if challenged, we'd be able to demonstrate that these individuals were not mistreated, but in fact were treated exactly like all other employees in that same department. The second example pertains to employees who were put on temporary leave prior to IDEL being introduced, with the anticipation that these individuals' employment would in fact automatically be terminated because there was no anticipation or expectation that they were going to be recalled in either the 13-week or the 35-week timeline set out in the ESA. In these scenarios, I still think an employer can move forward with the terminations because we'll be able to establish that the decision to terminate was contemplated prior to these employees being deemed to be on IDEL. So you start to see the thought process and the considerations that the Ministry of Labor and the courts will factor when determining whether an employee has violated the ESA or not when terminating an individual's employment who happens to be on IDEL. Similar to the Human Rights Code and the Occupational Health and Safety Act, we simply need to demonstrate that our decision to terminate someone's employment had nothing to do with them either being deemed to be on the leave or them electing to, requesting to be on the leave to provide care for somebody else or to provide care for themselves as they're symptomatic or needing to quarantine. I now want to turn to mass terminations. The fact is, there are a number of employers across the country that either are or will be going through this process in the coming months. As such, I want to provide some detail and consideration if you are contemplating mass terminations. It's important to remember that every province has their own framework for what constitutes a mass termination and the steps an employer needs to take. Additionally, if you are a bank or an airline operator, for example, and you fall within the federal scheme, you guessed right. you have your own set of rules under the Canadian Labour Code. Just to highlight some of the differences, in Ontario, a mass termination is triggered when 50 or more employees are terminated in the same establishment in a rolling 4-week period. By contrast, in Saskatchewan, a mass termination is triggered simply when an employer terminates 10 employees in a workplace in a 4-week period. So you start to see the differences across every province as it relates to what actually constitutes a mass termination. Now, what does this all mean? Why is it important to understand if we're triggering a mass termination? Simplistically, it generally means more notice is required to be provided to employees. For example, in Ontario, the amount of notice required to provide an employee increases as you terminate more employees, outlined as in the chart on your screen. Now, it should be noted that in Ontario, this notice can be provided through working notice or payment in lieu thereof. And these are in addition to any severance obligations you may have if you're a severance paying employer. Now, mass terminations in any jurisdiction are highly technical, and it's important to map out all of your terminations to ensure you're legislatively compliant. So many employers will do group terminations in tranches or waves, and you need to be aware of the timing of these tranches. For example, in your first tranche in an establishment, you may be terminating 400 employees. You go to the ESA, you look, okay, you need to provide 12 weeks notice. But if your second tranche falls within that same rolling 4-week period, you could easily move into the next bracket, and these individuals who you provided with 12 weeks notice were actually entitled to 16 weeks notice. So again, you want to critically evaluate your termination strategy, and in all cases, you actually want to seek out some counsel and advice to ensure that you're not your tranches are not being grouped together too quickly, so that you're actually incurring additional liability. So we talked about establishments. What does an establishment mean? Establishment will include all of your locations if the locations are located in the same municipality, or if one or more employees at a location have seniority rights that extend to another location. So if you only have one location in municipality, that's your focus. But if you're a retailer, for example, and you have multiple stores located in a municipality, here's where you need to partner with your entire, with your business partners and understand what is actually happening in all of your other stores, so that you understand where your numbers are at and whether or not you're getting up to those thresholds or not as it relates to group terminations. Now, there is an exception for which mass termination provisions do not apply. Now, the mass termination provisions do not apply if the number of terminated employees does not represent more than 10% of the employees who have been employed in that establishment for the last 3 months and are not caused by a permanent discontinuance of a part of the business. So this really focuses on your large kind of employers that, for one employer terminating 50 people in a 4-week period may be significant, but if you've got large groups and large numbers of employees working in a certain municipality or in an establishment, you won't trigger the mass termination provisions. Now, in addition to the enhanced notice periods owed in a mass termination, several provinces require additional administrative procedures to be taken. Now, sadly, the failure to follow these procedures can prove to be very costly for an employer. For example, in Ontario, we must submit a Form 1 to the Director of Employment Standards before we provide notice to that employees. Why is this important? The notice actually doesn't begin until the Director of Employment Standards receives your form. So there are several cases that all stand for the principle where you could have a situation where an employer does a group termination, they provide the requisite notice under the ESA, let's just say it's 12 weeks, for example, and 6 weeks into that, they realize they didn't actually provide or submit their Form 1. The case law stands for the principle that the 6 weeks that you provided notice, but you failed to provide your Form 1 to the Director of Employment Standards, that doesn't count. in terms of your notice period. So while you're tasked with trying to find efficiencies and right-sizing your business, especially during a pandemic, you could be in a situation where you actually incur additional costs simply because you didn't follow or abide by the administrative component of the mass termination provisions in your jurisdiction. So I'll say it again, it's highly technical. It's important to seek out the appropriate advice from your counsel to ensure that you are abiding by all the requirements in your jurisdiction. The other thing to think about is, as you do it in tranches and you terminate someone, group terminations, you want to critically map out the terminations so to ensure you're not, backing into a mass termination unknowingly. I now want to turn to the importance of employment agreements, as there has been a recent development based on a Court of Appeal decision that I'm about to walk you through. I've said it once, I'll say it again. A well-drafted employment agreement is the best ROI any employer can actually make. And it's important you have well-drafted enforceable employment agreements covering all employees from C-suite to Main Street. Now, the terms and conditions may be very different in your employment agreements, but again, you'll want certain staples to be included. That said, there's another case we need to bring to your attention as it relates to the termination provisions in an employment agreement. And I know, if you're frustrated with how the courts seem to be looking for any opportunity to invalidate termination clauses in employment agreements, you're not alone. However, it does stress the importance of having well-drafted employment agreements in place. Now, the case I want to walk you through is Waksdale. In this case, you had an employee who was employed for 42 years of age. He was employed as the director of sales, making roughly 200 grand a year, and had his employment terminated by his employer without cause after 8 months of employment. He filed a claim seeking 6 months reasonable notice. Now, the parties had an employment agreement which set out terms and conditions of the employment relationship. There are 3 important provisions that were included in this employment agreement. First, the employment agreement contained a provision stating that if the employee had his employment terminated without cause, he would be entitled to 1 week's notice in addition to his ESA entitlements. The second important clause was the employment agreement also contained a clause stating that if the employee's employment was terminated with cause, he wouldn't be entitled to any notice. Included in this clause was a laundry list of examples of what would constitute just cause. Third, the agreement contained a severability clause. And that's a clause that is typically included in employment agreements that simply speaks to the fact that if a court determines that one provision of an employment agreement is not enforceable, the rest of the employment agreement is still in full force and effect. So far, so good. 3, general issues that were covered in the employment agreement. But here's where the problem arises. Without any explanation or rationale, the employer in this case at trial acknowledged that the with cause provision included in the termination clause was in violation of the Employment Standards Act. Again, no rhyme or reason was provided for this decision. However, the employer took the position that the just cause provision should simply be crossed out and severed from the employment agreement. And given that this was a termination without cause, the rest of the termination provision should be read as is. On the other side, the employee argued that the termination clause needs to be read together. And because the employer has already acknowledged that the with cause portion of the termination provision was unenforceable, the entire termination provision was therefore void. Now, at trial, common sense prevailed, and the judge found that the employer was right. The judge simply determined that he had the ability to cross out the just cause provision, and the judge awarded the employee with his contractual entitlements, which was 1 week plus 1 week owed under the ESA. Unfortunately, it doesn't end here. In June of this year, the Court of Appeal overturned the original decision and found for the plaintiff. The court held that the termination provision has to be interpreted as a whole, and courts will not enforce termination provisions that are in whole or in part illegal. The Court of Appeal went back to the fact that the employer at trial agreed that their with cause provision was a violation of the ESA. So there you have it. I don't fully agree with this decision or fully understand the employer's strategy in this case, but the good news is they have sought leave to go to the Supreme Court, and this is a case that we will be following and providing periodic updates as they arise. Now, there's been lots of stuff written about this case, and the concept that if you have a just cause provision or you reference just cause in your employment agreement automatically invalidates your termination clause of your employment agreement is simply not correct. That issue was not actually addressed in this case because the employer in this case acknowledged or agreed that that part of the employment agreement was in violation of the ESA. So it wasn't actually determined or assessed in this case. That said, this is the law of the land at the moment right now, and we will provide updates as they become available. I'm now going to pass it over to my colleague, Leah, who's going to look forward to 2021 and really outline some of the the meaty issues that all of us will be having to deal with as we move forward.
Thank you, Sandeep, and good morning, everybody. I would like to start with a circumstance that I know many employers have faced, since the beginning of the pandemic and will continue to face as the pandemic continues. And that is what to do when an employee comes to you and says they don't want to return to the workplace because they have a fear of contracting COVID-19. And that fear may be of contracting COVID-19 in the workplace. It might be a fear of contracting COVID-19 on the commute to work. Perhaps they're taking public transit. But how should an employer respond in that circumstance? And the first thing the employer needs to do is answer a threshold question. Is the reason the employee is asking not to return, is there an underlying diagnosed mental health condition? Or is this a general fear or anxiety of contracting COVID-19 that many of us in society are facing? And the answer to this question is important because it dictates how the employer will respond. If the answer is the former, and there is a diagnosed mental health condition, then the employer's obligations under the Human Rights Code to accommodate the employee will be triggered. If it's the latter, and it's a general fear of or anxiety about contracting COVID-19, then the employer is going to have greater flexibility with respect to how to respond to the employee. So this brings us to a discussion that we have had many times pre-COVID-19, and that is about anxiety. And the fact that anxiety in and of itself is not considered a disability under the Human Rights Code, and it doesn't trigger code-based obligations. Certainly, anxiety can be a symptom of a disability. So anxiety can be a symptom of a generalized anxiety disorder, which does constitute a disability and would trigger code-based obligations. But anxiety in and of itself is not. So the first thing that the employer is entitled to require the employee to provide is medical documentation confirming the existence of a diagnosed disability under the Human Rights Code. And in addition to that, the employer is entitled to detailed medical information about the restrictions or limitations that the employee has as a result. And so it wouldn't be outside the realm of possibility for the employee to deliver a medical note that says, I have a disability and I need to remain at home or out of the workplace for the duration of the pandemic. And what we would say to that is that that is not sufficient because it's not up to the doctor to dictate to the employer what the accommodation is. What the doctor needs to provide and what the employer can require is information about the restrictions and limitations so that the employer then has the information necessary to determine what the appropriate accommodation is. And again, the appropriate accommodation is not necessarily what the employee's preferred accommodation is. So let's say you get a medical note that says, okay, the employee does have a diagnosed disability and needs to remain at home and needs to remain housebound because of their symptoms. It may be difficult in that circumstance to return the employee to work, but it may also be that the employee has symptoms of anxiety when in groups of 3 or 5 or however many, And in that circumstance, it may actually be possible to accommodate the employee in the workplace by perhaps you're in an office environment and you can provide an isolated office. Perhaps the employee can work off hours when there's lower traffic on public transit, lower traffic in the office. There may be ways, if it's the employer's desire, to accommodate the employee in the workplace, and the employer has the right to require information necessary to consider whether that's a possibility or not. And so some takeaways from this are that the employer has a right to and should request a doctor's note confirming the existence of a disability and getting enough information to determine whether accommodation can be accomplished in the workplace. If no medical condition exists, then the employer does have greater flexibility to determine how to respond. Because in this circumstance, if there's no diagnosed disability, the employee does not have the right to refuse to return to a safe work environment. And if the employee continues to refuse to return, then that can lead to a termination of the employee's employment. Now, I think we do have to acknowledge the practical realities of the world that we're living in right now, and that is that employees have very broad entitlement to infectious disease emergency leave, and that employees can take this leave because of their particular health status, and employers are prevented from asking for medical documentation to confirm that they qualify. And so I think if you have an employee who's very determined to remain out of the workplace for the duration of the pandemic, they may be able to do that by using IDEL, and it may be difficult to challenge that. But at the same time, it still is very important to know what your legal rights and obligations are as an employer and to be able to exercise those. The next thing that I want to talk about is the duration of infectious disease emergency leave. And so as Sandeep mentioned, there are 3 common reasons that an employee is going to be on infectious disease emergency leave for more of an extended duration. And the first is where the employee was initially put on a temporary layoff, but by regulation, that was deemed to be an infectious disease emergency leave. The second is where you have an employee who, because of their own health circumstances or health status, they are out of the workplace or on an infectious disease emergency leave. And the third is where you have an employee who's on IDEL because they are providing care or support for a family member because of a COVID-19 related reason. Now, in the first 2 circumstances, so where you have, because of the employee's health status, or their personal, because they're caring for a member of their family, there's no maximum amount of time that they can remain on infectious disease emergency leave. As long as they continue to meet the qualifying criteria, and as long as COVID-19 remains an infectious disease under government regulation, these employees will be permitted to remain on IDEL. It's a little bit different with respect to the first criteria I mentioned, where the employee is on a temporary leave of absence. They're deemed to be on IDEL, and that will end as soon as the COVID-19 period ends. And the COVID-19 period is currently scheduled to end as of January 2nd, 2021. Now, this deadline may be extended by the government, and we certainly expect that it will be extended, but at some point the COVID-19 period will end, and at that point, employees will no longer be deemed to be on infectious disease emergency leave and will convert back to being on a temporary layoff. And so we know once employees are on a temporary layoff that there's certain limits of time that they can remain on a temporary layoff before termination and severance entitlements will be triggered. And so usually it's, or often it's 13 weeks within a 20-week period. But employers can take certain actions to extend that period. So for example, you can continue the employee's benefits, or you can get the agreements of the employee, and then they can be on a temporary layoff for a longer period of time, for 35 weeks and a 52-week period. So a couple of things to think about. If you have employees on IDEL for reasons related to their personal or health circumstance, you want to keep in contact with them and make sure that they continue to meet the qualifying criteria. With respect to health circumstance, this can be a little bit challenging because, again, if they qualified originally for IDEL because of their health circumstances and an employer can't ask for medical documentation confirming they ever qualified or continue to qualify, it might be difficult. Those touch bases might be more difficult. But with respect to the personal circumstances, certainly it's possible that an employee was on the leave because they were providing care to a child who was out of school, but maybe that child has returned to school. Or perhaps they were providing care to a parent and maybe that parent is no longer residing with them, or they've made other care arrangements for that parent and the employee no longer qualifies for IDEL. So keeping in regular contact is a good idea, just to make sure those qualifying criteria are still met. With respect to the employees who are on a temporary layoff and therefore deemed to be on IDEL, you want to think about now what's going to happen when the COVID-19 period ends. Because as soon as that period ends, these employees will revert to being on a temporary layoff and the clock will start running on the temporary layoff period and when termination will be triggered. Maybe you are comfortable that you're going to be able to make a decision within a pretty quick period of time about whether to terminate or bring the employees back. But maybe you're not going to know what your business demands are like, how quickly you're going to recover, and you're going to want to buy yourself a little more time to make a decision about those employees. And if that's the case, it would be prudent to have a plan in place now. So are you going to try to get their agreement? Do you want to make sure you continue their benefits so that you can take advantage of that longer period of time? So the next thing I want to talk about is mandatory vaccinations. And this is an incredibly hot topic, and it's going to get even hotter in 2021. We just got word this morning that the Pfizer vaccine has been approved for emergency use in the UK and will be rolling out first shots next week. So we know that this is a topic, and it's our only path back to normal. So we know that this is an incredibly important topic to many, many people. Rate of uptake is obviously going to be key. A recent poll found that 69% of Canadians plan to get the vaccine once it's available, which is up from 63% last month. 22% have not yet decided, and only 42% support a mandatory vaccination program, which is not surprising. Mandatory vaccines were an incredibly contentious issue before COVID-19 and continue to be a contentious issue now, and will only more so in the future, I suspect. And we don't know what the government's going to do about this, whether there are going to be mandatory vaccination program legislation or not. We certainly know there's a precedent for requiring vaccination. So in Ontario, in order to attend public school, students need to be vaccinated. Now, there are certainly exceptions, and they're quite broad to this for medical reasons, or if vaccinations conflict with the parents' religious beliefs or their conscience, there are exemptions. But it's not without precedent that there can be legislation of this nature. Nana, as far as I know, the only province that has made a definitive statement about mandatory vaccinations is Alberta. So we know that Alberta has said that they do not intend to impose mandatory vaccinations, and instead they are going to use an education campaign to encourage the population to be vaccinated. And Alberta's even taken it a step further, because under their Public Health Act, the government currently has the ability to require mandatory vaccinations in the event of a public health emergency. And Alberta has said they plan to amend that legislation in the new year to remove that right. So we know Alberta does not intend to impose mandatory vaccinations. We don't know about the other provinces. We may see some legislation requiring mandatory vaccinations either in targeted industries, targeted occupations. If we do, I think we'll expect to see legal challenges, including charter challenges. So we'll have to wait to see how that plays out. In the private sector, there's been also a lot of chatter about mandatory vaccinations. And certainly there is some case law, which we're going to discuss in a minute, about mandatory vaccinations for the influenza vaccine that have arisen in the healthcare context. So we're going to look at some of those cases in just a second. But in the context of COVID-19, Qantas Airlines recently announced that they plan to require mandatory COVID-19 vaccinations for all international travel. Other airlines have not been as definitive, although there have been rumblings that other airlines are considering similar measures. Another example from the private sector is Ticketmaster, that floated a policy of perhaps requiring COVID-19 vaccinations or proof of a negative COVID test as a condition of entry to an event. Though there's nothing definitive, and Ticketmaster also said it would be up to the individual event organizers to determine what policy would be appropriate in the circumstances. All of this to say that there's a lot of discussion about it. We don't know where it's going to land, but we'll certainly endeavor to keep you up to date on it. So on that note, let's look at some of the case law that came out of the healthcare sector on mandatory vaccinations for influenza. Now, most of this case law comes out of the unionized workplace, so arbitral case law, where healthcare workers who provided care directly to vulnerable populations were required to receive an influenza vaccine. Now, outcomes in the case law are mixed. The policies generally, just to provide you with a brief description, would require the influenza vaccine. And if the worker refused, the consequences were non-disciplinary. So the worker would be sent home if there was an outbreak in the workplace of influenza, and not disciplined, just sent home. They would have potentially access to vacation credits or to unpaid leave. And to be clear, they were sent home even if they were asymptomatic. So they didn't need to be exhibiting any symptoms. The policies provided accommodation to employees who couldn't be vaccinated for medical or religious reasons, and particularly for medical reasons, there were options for paid leave. So as I said, outcomes were mixed. There's a line of cases where these policies were upheld, and in upholding them, the arbitrator considered the reasonableness of the policy by balancing the interests of the employee to protection of their bodily integrity, their privacy, the right not to be forced into medical treatment, against the employer's legitimate interest in protecting the vulnerable populations with which these healthcare workers work. There's one notable case in Ontario that didn't even engage in this reasonableness analysis, didn't even balance these interests at all, but looked at it as employees not being provided with a choice, because the choice between a vaccine and being forced to go home without pay isn't really a choice. So they were being compelled to get the vaccine. And the arbitrator found it tantamount to an assault, and found that it was a violation of the employee Section 7 charter rights. So as I said, case law has been mixed on this. And while I think it's very helpful, these cases are helpful in the sense that they give us an understanding of the types of issues that adjudicators will look at when considering whether these policies are lawful. There are really significant differences, obviously, between influenza and COVID-19. COVID-19 is a different beast. And so the factors and the weighing of the factors may be different. So for example, COVID-19, of course, has a much greater public health and safety risk than does influenza. And so there may be, particularly for vulnerable populations, and so there may be greater support for a mandatory vaccine in this context. There is no COVID-19 season in the same way that there is with influenza. So a lot of the cases talk about the consequences of the policy being fairly limited in time, and that they're limited to the influenza season, which is further limited to times where there's an outbreak of influenza in the workplace. That might not be possible with COVID-19, right? Because there doesn't seem to be a season, so the consequence of the policy may be longer. And then, of course, there's differences between the vaccines themselves. So with influenza, there was a lot of talk in the case law about how the vaccine, there's minimal side effects and they're very rare. We don't know what the safety profile is for COVID-19 yet. We don't know what contraindications might be. And so having a mandatory vaccination policy within that context may be less palatable. In terms of influenza, there is also talk in the case law about how it's not always terribly effective, and in some years there's such a mismatch that it's really not effective. We don't get the early indication is that COVID-19 is quite effective, the vaccine is quite effective, and so there may be a stronger scientific justification for the vaccine in that context. That said, the corollary of that is that the case law also talks about the fact that it was very important for healthcare workers to get vaccinated for influenza, because the vaccine was so ineffective on the patients, the vulnerable patients that they were serving. And so even if those patients were vaccinated, it wouldn't be helpful. And that's why it was so necessary for the staff to be vaccinated. Might not be the same problem with COVID-19, right? So there might not be that compelling reason to force healthcare workers to be vaccinated. So all of those things are going to play into these determinations, and certainly we'll have to wait to see how they play out. And I'm certain that other factors will come into play as well, because COVID-19 is so unique and so different and unprecedented. If you're considering a vaccination policy, a couple of things to think about. If you're a non-unionized employer and you implement a mandatory vaccination requirement, you could face a claim of constructive dismissal because you're unilaterally implementing a new term or condition of employment that is not being agreed to by employees. In a unionized workplace, you're most likely to face a policy grievance alleging that the policy is unreasonable. And on this point, I would note that, especially in the healthcare sector, unions have negotiated into the collective agreements provisions that prevent employers from requiring mandatory vaccinations. So depending on how those provisions are worded, whether they just prevent mandatory influenza vaccinations or whether they're more broad than that, it might be difficult for the employer to impose a mandatory vaccination requirement absent legislation that overrides the provisions of the collective agreement. If you are considering a policy, you're going to want to make sure that it accounts or provides for accommodation on human rights grounds, particularly disability and religious reasons for not becoming vaccinated. You also want to look at your workplace. We think it's going to be difficult to impose sort of broad-based requirements that every employee be vaccinated for COVID-19. We think it's probably going to be, you're going to need to look at your workplace and consider what the jobs of what the positions of the people are, what they're doing, what's the nature and duration of employees' contact with the population that they're serving, and assess risks for different positions. You're going to also want to think about strategies to create buy-in, to get employees to voluntarily vaccinate before jumping to a compulsory policy. This is going to be particularly important in a unionized environment because arbitrators, when considering whether a policy is reasonable, are going to look at less intrusive ways that the employer tried to get employees to comply. So things like education about the vaccine, offering paid time off to get the vaccination are going to be important considerations before you jump to that stick approach. You want to make sure that the policy is clear and that employees understand the consequences for non-compliance. And now in the healthcare context with influenza, we talked about the fact that the policies were generally non-disciplinary. I think that might be different for COVID-19. There isn't a COVID-19 season, so there isn't this natural sort of temporal restriction on the consequences of the policy. And obviously COVID-19 is a much bigger health and safety risk. So it may be possible to have policies where if the employee refuses to get vaccinated, their employment is terminated. You want to use public health guidance and potentially legislation if it's available to support or strengthen your position that the vaccination policy is reasonable. Certainly that's something that got a lot of play in the influenza case law, that where there was this advice from public health, it really did serve to strengthen the policy. And then again, when in doubt, you're going to want to consult legal counsel to help you draft a policy that is reasonable and that balances all appropriate interests. And we, of course, again, will keep on top of this and provide you with updates as they become available. And no doubt there will be many as we head into 2021. So that brings us to the end of our presentation today. So I think we're going to open it up to questions at this point. And I am going to transfer to give it back to Sandeep to answer the first.
For sure. Thanks, Leah. It's great. So we received a number of questions throughout the last hour or so. And so we're just going to kind of go down them as they kind of came in, and hopefully we addressed all your questions. So the first question received was, what is the definition of temporary in the context of a work from home and a constructive dismissal issue? Is it 6 months, 12 months? The short answer is it depends. Time may not actually be the test in this case. What we're really following is what public health tells us. Public health continues to recommend a work from home model when possible. And so I think we're tied to really what the medical opinion actually is from a public health perspective, and not so much defined timelines of, when it becomes, a temporary to a permanent from that perspective. Next question I got was, does there need to be written documentation to determine when an employee switches from IDEL to temporary layoff? No, there's no requirement in Ontario for written notice of layoff, but we may want to in terms of a best practice, but it becomes really a personal business decision as opposed to a legislative obligation. Would increased costs of work from home be offset by savings of commuting in the context of a constructive dismissal case? Absolutely. I mean, we would take that position if this claim ever came through the door, that you have to look at the other way as well in terms of saving gas costs, parking costs, and whatnot. To mitigate all of this, you just may want to look at your expense reimbursement policy to reduce any claim that working from home has resulted in a material increase in expenses. Next question. If we are hiring virtual hires, which a number of us are, is it a best practice to tell them that we will eventually return to a physical workspace? Absolutely. Sometimes it takes a pandemic like this to actually revisit certain clauses in our employment agreements. And in our offers, we're now specifically outlining all of that. Usually, we used to say different locations within the same city, but now we're actually incorporating work from home as well as the physical workplace. So yes, if that is the expectation from a business perspective, we should absolutely communicate that, both verbally and in writing. Next question, in the context of a mass termination, what does a rolling 4-week period mean? It just means any block of 4 weeks. So it's a continuously moving piece depending on when an employee is terminated. And remember, in the context of calculating our numbers, if we're using working notice as, in terms of our obligations under the ESA, remember that the termination actually occurs at the end of the working notice period, not when you've advised them. So you need to factor that into your decision and your calculation in terms of how many numbers and how many individuals you're actually terminating. Next question, Waksdale question. Why was the termination for cause provision in the employment agreement a violation of the ESA? It's a great question. This is the challenge. The employer counsel agreed at the onset of the trial that it was a violation of the ESA. Now, and I can only guess and speculate here. In that employment agreement, the just cause provision contained a laundry list of what actually constituted just cause. So my guess is counsel thought a court could determine that the examples used as just cause wouldn't actually constitute just cause at the common law perspective. However, I think it was a big leap and one that so far has looked to be challenging to suggest that that clause was a violation of the Employment Standards Act. And I think that's the bigger challenge. And this is the frustrating part for all of us who are sitting on the outside watching this case and watching plaintiff side counsel kind of waive this decision, is it doesn't stand for the principle or the analysis of whether or not that clause actually violated the ESA. The next question is, how does an employer protect themselves if termination clauses were written in an employment agreement and signed before this case went to court? Yeah, absolutely a frustrating, side of things. But remember, as an employer, we have the ability to introduce new employment agreements during someone's employment. Yes, it's much easier and cleaner when we do it at the onset of someone's employment prior to them commencing. But even during an employment relationship, we absolutely can introduce employment agreements. And that's why it's important to continuously, annually look at our employment agreements to assess whether or not they're still enforceable or not. The key there is, are we giving consideration? You got to give to get. So if you're getting a new employment agreement, one that adds extra protections for your business, you got to give. And what that give looks like, it could be a pay increase, it could be something that the employee is not automatically entitled to. At that point in time, we can introduce our new employment agreements. What if a business owner has, next question, what if a business owner has opted to sell their business while they have employees on a leave of absence or idle? How should they proceed, or what should they take into consideration? In that case, we should operate in the same way we otherwise would. If all employees would have been terminated when the fact the employee is on leave, then this is not, this isn't going to change our approach. If the purchaser wants to have the employee continue, then you'll still proceed on that basis, and they will continue as employees of the purchaser, albeit potentially on a leave when they're inherited by NewCo. And the last question I am going to address is, can clear advance notice of a pending closure termination, so 6 months, 12 months, apply towards the common law obligations, assuming the minimum ESA notice and severance requirements are still met or exceeded? Yeah, absolutely. If we provide written notice, that time frame can absolutely count towards mitigating our common law obligations. So yes, you can utilize that component to get there. And sorry, I got one more question that just came in, which I'll address. If an employee took leave to care for, a child, but now wants to come back, but there is no work for them, i.e. the position has been eliminated, what are our obligations as an employer? Can we terminate without cause, proper payout? What are the risks? Good question. At the very least, it'll be a termination without cause. So leave that aside and we'll owe our ESA and common law or contractual notice. But remember here that under the ESA, the individual has an entitlement to return to a comparable position. So like our human rights analysis, we need to be able to demonstrate that there are also no comparable positions available for that person. So this is where you get to the example that I use in the presentation with respect to you're eliminating a department. If you're eliminating a department and there happens to be people who are included in that department who are on leave and not on leave, and you've terminated them all, well then from that perspective, you've got a really strong defensible case if there's a challenge. Again, though, this is a situation where you want to, probably get some counsel in terms of just how to navigate through that, because there could be some steps to take to mitigate further liability. I'm now going to pass it back to my colleague, Leah, who's going to address some of the questions that came in specifically for her.
Thanks, Sandeep. Okay, so the first question I have is, when an employee is refusing to come to work, not dealing with the public out of fear of contracting COVID due to their pre-existing medical condition, yet continues to go shopping, dining out, using beauty salons, and babysitting grandchildren, can that be viewed as an unauthorized leave, even though their doctor provides a note that they have mental anxiety and therefore cannot work? So they may not be entitled to the infectious disease emergency leave because they're not self-isolating, but you still need to consider if there is an accommodation issue related to anxiety. So you're probably going to want to go back to the doctor to ask for more detailed medical information to evaluate, and ask the doctor to, and it's appropriate to ask the doctor to provide some insight on the discrepancy as well. So that's an approach you can take too. If an employee is claiming they cannot return to work and would like to remain on infectious disease emergency leave because they live with an elderly parent or grandparent and do not want to contract anything and bring it home, is there anything we can do? And I would say to that in order to qualify for infectious disease emergency leave, they need to actually be providing care and support to their family members. So if that's not the case, then they're not going to be eligible for infectious disease emergency leave. Okay, the next question is an accommodation for mental health for a shorter workday, when the doctor suggests a reduced schedule for mental health, we struggle to know if we can question this. And I think in this circumstance, you want to ask for the actual limitations and restrictions so that you can make a determination about whether there is a basis to require a shorter workday in the circumstances. Because again, it's not up to the doctor to say, it needs to be this or that, or to tell the employer how they need to accommodate or how they need to run their workforce. What the doctor needs to say is, here are what the restrictions are. And the employer then needs to make a decision assessing those restrictions as to what accommodation may be appropriate. And so it may be that the employee needs more breaks. There might be other ways to do it other than simply shortening the workday. Is there a requirement that benefits be continued during infectious disease emergency leave until January 2nd, 2021? Good question. This is a little bit of a confusing one. So if the employee was placed on a layoff or infectious disease emergency leave after May 29th, the employer had to continue benefits and will need to continue benefits until the temporary layoff is no longer deemed to be an infectious disease emergency leave. If the employee was on temporary layoff prior to May 29th without benefits, then there's no obligation to continue benefits. However, if they did have benefits when they were on a temporary layoff, then the employer does still need to continue benefits. What happens if vaccinated employees don't want to work with unvaccinated employees? And so this is a question of whether this would be sort of a legitimate work refusal in the circumstances. And it may not be, because presumably if a person is vaccinated for COVID-19, then they're protected. And so the unvaccinated employee should not pose a risk to them. So I think that's probably where that question would go. Although again, we'll need to see how those types of questions play out. Can an employer ask for medical documentation to support an infectious disease emergency leave? And the answer to that question is no. I appreciate that it's counterintuitive for employers. There are very broad circumstances in which an employee can say that because of their health status, they need to be on infectious disease emergency leave. But in that circumstance, the employer cannot ask for medical documentation corroborating that. So the next question I have is, what happens if an immunocompromised person cannot get the vaccine? And likely it will be the case that with any policy that there absolutely needs to be carve-outs or provisions made for employees who can't get the vaccine for medical reasons or for religious reasons. So we do need to always consider code-based obligations and ensure that the policy is accounting for those. Is there a list of COVID-19 related reasons for being entitled to an infectious disease emergency leave? And here, the Employment Standards Act sets out the categories of people who will be eligible. However, whether or not someone falls into any category is not set out expressly in the legislation, as this is often going to depend on the reason for the request for the leave and public health guidance. So for example, those groups that public health has recommended should isolate at home due to heightened risk, and also the assessment of the individual's physician. What happens if we have an employee or an entire department on infectious disease emergency leave and we're now prepared to call them back? And if someone says they will not be returning at all during the pandemic? So as we chatted about, if they're not eligible for infectious disease emergency leave for another reason, for providing care and support, and they don't have a medical disability to justify remaining home, then they're going to be required to return. This isn't really an optional situation, and it would be open to the employer, sort of absent that reason for leave or absent a human rights-based reason that the employer needs to accommodate, to terminate that employee's employment if they refuse to return to the workplace. So the next question I have is, does a professed medical inability to wear a mask in a mandatory mask environment qualify as a job protected leave, or is it just a regular unpaid medical leave? So this may cross into two categories, because while it could be a medical accommodation if the employee has been directed not to attend at work if they're not able to wear a mask, then it would also be considered an infectious disease emergency leave because it falls within one of the infectious disease emergency leave categories, and that is that the employee is under the direction given by his or her employer in response to the employer's concern that the employee might expose other individuals in the workplace to a designated infectious disease. I am now going to turn it over to Sandeep to answer a few more questions.
Thanks, Leah. A couple more just came in, so we want to address them. If an older employee is on voluntary leave of absence since March due to medical risk or fears associated caused by the pandemic, do they qualify, for IDEL? It may. We need to look a couple more details. But if the doctor has told them that they're at a higher risk and should isolate, then yes, they would be covered. In addition, public health has said people over 70 are at heightened risk and should isolate. So when you mirror that together, we may, need some more details, but when you marry those two kind of provisions together, then there is a good chance that that individual would qualify for IDEL leave. To confirm, employees may be temporarily laid off after IDEL. When the IDEL expires, they will automatically be on temporary layoff if not recalled. So it just automatically transitions to the layoff, and it's on us to recall them back. And lastly, in the case an employee states that they have an existing health condition and wants to work from home, can a shift change be considered a reasonable accommodation? It absolutely may. What we probably need to do is get a better understanding of what is it about their existing health condition that requires them or renders them unavailable or unable to work a specific shift. So we got to go back to the doctor, try and get some more medical information in terms of why they can work one shift but not the other. What is it about their condition that makes this something that we actually need to accommodate? And I'm going to pass it back to Leah now, who's going to deal with a couple more questions.
No, I think that's the end of the question. So this takes us to the end of today's program. We hope you found the program helpful and informative. If we didn't get a chance to, we did get a chance to answer all of your questions, but if you have any that come up, please feel free to drop us a line and we'd be happy to answer them. Our next HR review will take place on Wednesday, February 24th, 2021. The topic is in the design phase and we will send out an invitation in due course. If you are on our mailing list, you will receive the notification. If you're not yet on our mailing list to receive our briefing notes, newsletters, and invitations to seminars and workshops, please subscribe through our website. Thanks again for joining us. Have a great day and please stay safe.